Do you want an easy and stress-free marriage immigration journey?
If so, you must avoid the 5 mistakes we'll be discussing today. If you don't, these mistakes will significantly complicate your journey.
Remember, we are a one-of-a-kind channel combining our personal marriage immigration experience and experience as immigration lawyers to help you through your own marriage immigration journey.
So be sure to subscribe and absolutely click the bell so you're always aware of the most recent changes and updates.
Also, be sure to grab one of our free marriage immigration resources. You can download them completely for free at the links below in the description.
This time around, we want to start with the biggest mistake we see couples make when first considering filing for an adjustment of status, since we receive messages regarding this particular situation daily.
But make sure to watch until the end, because the last mistake is one that you need to avoid making until you're a citizen and are completely done with your entire immigration journey.
So here's mistake number 1. You know what the easiest way to complicate your immigration is? By leaving the country. So here's the scenario that we're talking about. What often happens is that a couple has been dating for a while and a foreign partner keeps coming in and out of the United States for sometimes prolonged periods of time, but otherwise the relationship is long distance.
And then the day comes where both partners are sick and tired with the whole long distance thing and they decide to get married. From there, it normally goes in a couple different ways.
First, the couple gets married and the foreign spouse departs the US, maybe to handle some personal affairs back home. But the ultimate plan for them is to re-enter the US and file for a marriage adjustment of status. Or, partners do not get married, but decide that the foreigner will leave the United States to handle their affairs, but that they will get married and file for an AOS when they get back.
What you need to know is that if you follow either of these two approaches, the US immigration authorities expect spouses to apply for a marriage visa through consular processing, where you will go through the process at the US Embassy in your home country. In this case, the US citizen would start the process by filing Form I-130, after which the immigrant communicates with the overseas US Embassy and attends an interview there.
However, this can take months and even years, during which time the US petitioner is normally living in the United States while the immigrant lives in their country. So, instead, if your loved one is currently in the US and you guys made the decision to get married, you want to apply from inside the United States, because it's typically faster than consular processing, and the foreign spouse gets to stay in the United States while waiting for their green card. Additionally, the foreign spouse will be permitted to work in the US in the meantime, so long obviously as you apply for and get approved for a work permit.
Consular processing is taking years as opposed to marriage adjustment, but it is important you do it right on the first try, otherwise you are risking complicating and most importantly prolonging your case, since even a small mistake in the beginning of this process can take years to be fixed.
Remember, it all comes down to your intent at the time of entry in the United States. You can't enter the US on a tourist visa with the intent of applying for immigration benefits. But what often happens is that a foreign partner would come in on a tourist visa without an intent of staying, and then later they would change their mind, which is completely normal.
But the USCIS can ask for evidence that you did not have an immigrant intent and that you did not misuse your tourist visa, in other words, commit visa fraud by claiming to be a mere visitor when in fact intending to stay and get a US green card.
By the way, couples often reach out to us asking if there's a specific time that they need to wait after entry and prior to getting married and applying for a green card. We made a video discussing it and you can watch it here.
Next is mistake number 2. Another mistake that we see often leads to green card denials is the couple's failure to establish a valid and authentic marriage. The most essential part of your green card application is proving that you and your spouse have a legally recognized marriage and that your relationship is authentic.
Remember, this marital relationship is the foundation for your eligibility for a green card, and it's your responsibility to demonstrate that to the USCIS.
The first step is proving that you have a valid, legally recognized marriage. In simplest of cases, the USCIS needs to see a copy of your marriage certificate. There are a number of ways that this can become more complicated, however.
Your marriage must be valid and legally recognized in the place where you were married, and you have to prove that any previous marriages ended before your current marriage started, and this can be by either including divorce or death certificates for any prior marriages.
The second part of establishing your marital relationship is proving that your marriage is authentic rather than a marriage entered into solely for the purpose of obtaining a green card. You and your spouse must provide evidence of your relationship and your life together, such as financial documents, by far the strongest evidence the USCIS is looking for, documents showing that you live together, photos from trips together, and birth certificates of your children, also the strongest evidence you can potentially include.
We've seen a lot of RFEs recently where the USCIS was asking for couples to supplement their applications with additional bona fide marriage evidence. But we've also seen cases denied because couples failed to establish that they had a bona fide marriage.
We made a video discussing different examples of evidence you need to submit with your application, so make sure to check it here. Plus, don't forget to download our free bona fide marriage evidence list under this video.
Now, we also really need to discuss errors on the green card application, including honesty. It goes without saying, but you must be honest on your application, and the best approach is to assume that the USCIS already knows.
For instance, if you worked without authorization, you have to disclose it. It is often hard for immigrants since they're deathly afraid of repercussions, but if you're married to a US citizen, your unauthorized employment will be forgiven.
Now to mistake number 3. This mistake is not having all of your documents properly translated. As a part of your application, you will likely submit documents in a non-English language, such as birth certificates or marriage certificate. If you do provide a document that is not in English, you must also provide a word-for-word English translation as well. Include both the non-English version and the translated version in your application, and make sure that your translation is certified.
To be certified, the translator must certify in writing that he or she has translated the document accurately. This certificate should also include the translator's name, address, signature, and date the translation was completed.
But did you know that the USCIS doesn't require official translations? Anyone can translate your documents so long as they're fluent in English and the language you need translated.
Let us know with a quick comment below if you just learned this. And seriously, I've seen a case denied last week because a couple included a translation of a birth certificate but not the actual foreign certificate. So make sure you're always submitting the document in a foreign language and the translation.
Now mistake number 4. Another thing is that when it comes to applications, couples often submit incorrect filing fees and also send their applications to the wrong address. Now, we've included 2 links below to help you calculate your filing fees and also determine the appropriate filing address. But if you have any questions on this, please drop them in the comments section and we will definitely get back to you.
All you need to know here is that you won't be sending your application to your field office. Your field office is where you will have your biometrics appointment and your interview appointment, but you're sending your packet to a completely different address.
Finally, we have mistake number 5. Now, this mistake refers to inadmissibilities and generally under what circumstances you should not be filing for a green card. By the way, if you're a J1 visa holder, you need to check out our video on what steps you need to take to make sure you're not subject to a 2-year home residency requirement, since that's a very common mistake that applicants make.
Remember, being married to a US citizen or a green card holder does not always mean that you're eligible to apply for a green card from within the United States. If you entered the US on a tourist visa, either on a tourist visa or under the visa waiver program, and applied for a green card less than 60 days after arriving in the United States, your application could be denied unless you can prove that you did not intend to apply for a green card when you entered the United States.
If you entered the United States illegally, you aren't eligible to apply for a green card from inside the United States. If you're in this situation, you would need to apply for a provisional unlawful presence waiver and then apply for a green card at the US Embassy or consulate in your home country.
Additionally, some, but not all, types of criminal records could make you or your spouse ineligible to apply for a green card. If the spouse seeking a green card has a communicable disease, a mental illness, or a history of drug abuse, he or she could be ineligible for a green card, and that's the whole point of a medical exam, and that's why each green card applicant has to complete it.
Finally, any kind of misrepresentation or dishonesty to immigration officials is considered fraud and will prevent you from getting a green card. What we often see is that when people apply for a tourist visa, they sometimes claim to be married since they believe that it will improve their chances of getting one.
But it backfires big time when they actually meet someone that they love here in the US and try to apply for a marriage adjustment of status. Plus, of course, lying on your application and during your marriage-based interview is a huge no-no as well.
Even for someone who is otherwise ineligible for a marriage-based green card due to a criminal record, a medical issue, or prior immigration fraud, it still may be possible to qualify for a waiver of inadmissibility. Typically, the USCIS will only grant such a waiver when presented with proof that a US citizen or green card holder's spouse would suffer extreme hardship if his or her spouse could not live in the United States with them.
And one final point on inadmissibilities is that you need to make sure that you don't become inadmissible from before you start and maintain a clean record until you're naturalized. The USCIS will reevaluate your case at every step of the process, So you need to make sure that you're responsible and do not jeopardize your case.
Avoiding mistakes is extremely important as U.S. immigration laws are notoriously unforgiving. The best way to avoid mistakes is to know exactly what to do without guessing from the start.
That's why, before you do anything with your marriage adjustment of status, you should schedule a call with us. Our marriage immigration method will provide you with everything you need to successfully navigate your conditional green card, removal of conditions, and citizenship.
It's easier to do this right on the first try than to fix mistakes later on. All links are in the description below.
Please like and subscribe if you enjoyed this video, and be sure to check out these other videos we've included at the end.
Otherwise, have a great day and we'll see you next week with our newest video.